Bismillah ar-Rahman ar-Rahim. In the name of my late father, President Mubarack, on behalf of my family and for the historical record, I want to underline some essential points regarding our legal proceedings before the EU courts and beyond. That is of particular historical significance, given the consistent international media campaign of false allegations of corruption that was unleashed against my family almost 10 years ago. My family has decided that we simply cannot stay silent anymore in the face of such persistent defamatory reporting. It is time that the family responds, and directly. This statement represents our response in that respect. Since 2011, various investigative measures and sanctions were initiated against members of the Mubarak family in the EU and beyond. Of particular significance were the wide-ranging restrictive measures imposed by the EU Council against the President and his family. These proceedings, which lasted well over 10 years, have just reached their conclusion. They have fully exonerated us and vindicated the position my family has held for over a decade, confirming specifically that the EU sanctions against us were always unlawful. It was indeed the wish of my late father to have such proceedings explained to the world at large. His passing before such proceedings were concluded means that I carry that burden on my shoulders, a burden that I carry with pride and commitment. When President Mubarak decided to step down in February 2011, he declared his readiness to confront and comprehensively answer any criminal allegations against him and his family. He declined to accept immunity of any kind and categorically refused any suggestions to leave Egypt. He asserted in a recorded message broadcast in April 2011 that Egyptians need to know that their former president held funds in only one bank in Egypt. He also welcomed any probes into his and his family's assets. Since that time, and until he passed away, President Mubarak, together with his family, endured countless investigations and court proceedings, both in Egypt and overseas. The President and his family participated in all such proceedings with the utmost of respect to the judiciary and to the judicial process. In so doing, President Mubarak affirmed a cardinal principle enshrined in the rule of law, which he so deeply respected, that no one is above the law, including the President. More than 10 years ago, a ferocious campaign of false allegations of corruption was unleashed against President Mubarak and his family. The forces opposing the President seized on these allegations to inflame popular sentiment, significantly contributing to the ensuing political events that transpired in Egypt in January and February 2011. That campaign continued unabated for over 10 years while we were consumed with fighting our legal battles. The question has arisen as to why my family sought to bring proceedings before international courts to start with. This was never a step we envisioned taking. We were fully committed to vindicating our position solely before the Egyptian judiciary. However, our hand was forced by the Egyptian authorities, who made a deliberate decision to pursue us in international jurisdictions. Such relentless pursuit was based on the false and outrageous pretext of funds allegedly pillaged or siphoned by my family overseas. All domestic criminal proceedings initiated against us were submitted as evidence to the relevant international authorities. The aim was to recover funds that it was alleged had been illegally taken by my family. Following requests from Egypt, various overseas authorities took preventive measures, introduced sanctions, and opened investigations into members of my family. The aim was to verify whether the allegations made against us in Egypt were well-founded or had any links with any assets held overseas. This included the EU sanctions that were specifically and solely based on the Egyptian proceedings against myself and my family. We were therefore left with no choice but to vigorously defend our position before judicial authorities in foreign jurisdictions. My family has had to endure a 10-year fight to rebuke each and every defamatory allegation made against us. This fight included our aim to annul the EU sanctions imposed against us and prove their unlawfulness. We were patient, persistent, and unwavering. We have not allowed any of these falsehoods to remain unchallenged. And challenge them we did, including through successful judicial proceedings before internationally respected courts and investigative authorities. It is finally time that the record is set straight once and for all. Today, and after 10 years of incredibly intrusive investigations, a litany of international mutual legal assistance requests among various judicial authorities, and a multitude of judicial proceedings in several jurisdictions, it is proven that all the allegations leveled against my family were utterly false. There is not a single shred of evidence that my late father or my mother ever held any overseas assets of any kind. Not a single allegation of assets hidden overseas by other members of the family turned out to be true. All our assets were transparently and willingly declared in line with applicable statutes. Not a single allegation regarding the professional business activity of myself and my brother was true. All our income was judicially confirmed to have originated from lawful sources. With the benefit of vast powers, including requiring suspects to explain the sources of their assets, not a single judicial authority in any EU member state, or indeed in any other foreign jurisdiction, has discovered any legal violation of any sort by me or my family. So in conclusion, no illicit assets, no concealed assets, and no unexplained sources of assets have been attributed to any member of the Mubarack family by such authorities. These are the facts. They are independently and judicially verified and thus irrefutable. While EU sanctions imposed against President Mubarack and his family were lifted back in March 2021, we continued our legal battle against the EU Council in the EU courts. We aimed to prove definitively that the sanctions were unlawful from the outset for relying on proceedings that violated our fundamental rights. Our challenge against such sanctions was never primarily driven by unfreezing any funds. In particular, as my late father and my mother never owned any assets of any nature outside Egypt. It was primarily driven by our desire for vindication, to judicially prove that such sanctions, which affected our reputation significantly, were unlawful from the outset. Almost 5 weeks ago, the EU General Court issued a landmark decision. For 10 consecutive years, the EU Council used its most direct and punitive foreign policy tool to impose restrictive measures against President Mubarack and his family. The Council maintained the view that it had no obligation to verify whether the underlying Egyptian proceedings respected our fundamental rights. In December 2020, the Court of Justice of the EU, the highest court in the European Union, made clear that the Council was fundamentally wrong. In its most recent oral pleadings before the EU General Court, the EU Council admitted that it could not rely on some judicial proceedings against my family in Egypt. The EU Council confirmed that this was because fundamental rights were not respected in those proceedings. In its decision last month, the EU General Court has now gone one step further, ruling that none of the other Egyptian judicial proceedings can be lawfully relied upon by the EU Council. The Court reiterated fundamental legal principles as established by its jurisprudence. Of particular relevance is that in criminal proceedings, observance of the rights of the defense and the right to effective judicial protection represents particular aspects of the right to a fair trial. That is guaranteed in particular by Article 6 of the European Convention for the Protection of Human Rights and Fundamental Freedoms. The Court added that those same rights are also guaranteed by Article 14 of the International Covenant on Civil and Political Rights to which Egypt is a party. The Court ruled that the relevant Egyptian authorities, and I quote, prevented the applicants from exercising their rights of defense. The Court also asserted that where proceedings witnessed, and I quote, numerous delays attributable to the Egyptian authorities, and where proceedings without justification are left open indefinitely, it should have legitimately raised doubts in the mind of the Council as to whether the applicant's rights to effective judicial protection were indeed respected. Based on this most fundamental principle of EU law, the Court has ruled the sanctions to be unlawful. It also ordered that they be, and I quote, removed retroactively from the legal order of the European Union and is deemed never to have existed. The significance of this ruling, which provides for the annulment of the sanctions from the outset, cannot be overstated. It represents a further vindication of my family's position that the EU sanctions against us broke the law and violated our fundamental rights. With all due respect to the institutions of the EU, the implementation of its sanctions policy need not, should not, and cannot trample on any individual's fundamental rights. The EU Council cannot have it both ways. On the one hand, expressing respect for fundamental rights as anchored in its charter, while on the other hand, exhibiting flagrant indifference to those same rights in our case. We now know that by doing so, the EU Council broke the law. This should undoubtedly be a cause for real concern to the international community. The EU Council was eventually left with no choice but to lift its sanctions back in March 2021. It announced back then that the sanctions had served their purpose. It is difficult to understand how sanctions that were ruled unlawful by the highest court in the EU could have served any legitimate purpose. We have already received a substantial payment from the EU Council to refund our legal costs, as ordered by the EU Court of Justice. We will undoubtedly recover more of our legal costs from the Council, as ordered by the General Court in its decision last month. I have also instructed our lawyers to actively consider all possible legal avenues to pursue damages claims against the EU Council for its conduct towards me and my family. The EU General Court decision was preceded by decisions in our favor at the EU Court of Justice on December 3rd, 2020, and by the UK government's acceptance that the same underlying judicial proceedings against the Mubarack family in Egypt do not meet the required legal test under UK law for sanctions to be imposed. Moreover, it was also immediately followed by the definitive decision of the Swiss Federal Prosecutor's Office, fully exonerating me and my brother after finding that all the allegations leveled against us were unfounded. The Federal Prosecutor, after an exhaustive investigation lasting well over 11 years, which witnessed our full participation, proving the lawful origin of all sources of assets, asserted in his decision that the investigation, and I quote, has failed to establish even a tenuous connection to any offense. The decision added that the investigation, and I quote again, did not make it possible to highlight a suspicious transaction, allowing to link the assets to criminal acts, in particular those alleged by the Arab Republic of Egypt. It is recalled how the media has repeatedly casted an image of a closely knit structure put in place for the purpose of self-enrichment, comprising senior officials within the Mubarak regime, together with their allies in the business community. Yet the Swiss Federal Prosecutor has put to rest this false claim. The investigation has dispelled this notion entirely. The Federal Prosecutor's decision confirmed that all allegations that senior members of the Mubarak regime would have diverted public funds for self-enrichment within the framework of such a group is entirely without any merit. This significant and historic decision brings to an end all international judicial proceedings involving the Mubarak family. The facts have now been established, and the false allegations have been unequivocally rebutted. The historical record has thus been independently and judicially corrected. Within this context, I have asked our lawyers from now on to reserve all our rights against any defamatory reporting about my family in that respect. Finally, I must end this statement with a few words dedicated to my late father, President Mubarack, who could be looking down upon us right now. والدي العزيز، لم يمهلك القدر لتشهد نهاية جميع الإجراءات القانونية التي تم اتخاذها ضدك منذ عام 2011، بما في ذلك الإجراءات ذات الصلة التي اعتمدها مجلس الاتحاد الأوروبي. ولقد أكدت لك خلال أيامك الأخيرة أنني سوف أستمر على الطريق لتحقيق تبرئة لا لبس فيها لك ولأسرتنا. لقد وعدتك بمواصلة الطريق بتصميم لا يلين لتحقيق هذه التبرئة في ساحة القضاء الدولي. وبعد معركة طويلة وشاقة على مدار أكثر من 10 سنوات، صدرت أحكام وقرارات متتالية باسمك وباسم أسرتنا من قبل أعلى السلطات القضائية في الاتحاد الأوروبي وخارجه لتبرئنا وبشكل قاطع. طوال هذه المعركة وحتى في أحلك أوقاتها كنت أنت دائما على ثقة رغم كل الصعاب بأننا سننتصر في النهاية حتى ولو بعد رحيلك. ولقد رحلت عنا يا أبي، ولكننا بالفعل انتصرنا وفي ساحة القضاء. لقد كانت هذه هي معركتك الأخيرة خلال تاريخ حافل بالمعارك والصعاب، معركة واصلتها نيابة عنك، معركة واجهتها أنت بصبر وببسالة بعد أن أفنيت عمرك في خدمة الوطن، محاربا من أجله ومدافعا عن مصالحه. لترقد يا أبي في سلام، ويتغمدك الله برحمته ومغفرته.